Most families assume that when someone passes away, they can just go to the bank and access the money. They're thinking, we're the family, we just need to handle things. But that's not usually how it works. In fact, one of the biggest surprises families face after a loved one passes away is realizing they cannot access the money right away. I'm attorney Otto, a Florida estate planning attorney, and I want to walk you through what actually happens to a bank account after someone dies and what determines whether your family can access those funds immediately or not. Let's start with what people expect. Most people assume that if they are a spouse, a child, or even the person that's handling everything, they'll be able to go to the bank, show a death certificate, and access the account. But in many cases, the bank will simply say, no, sir, no, ma'am. And why is that? Because the bank is not allowed to just release funds without proper legal authority. And until that authority is clear, that account may be restricted or completely frozen. Now, let's talk about what actually controls what happens. There really are three key factors that determine whether your family can access your bank account after you pass away. First, whether there is a joint owner on the account. Second, whether there is a named beneficiary, also known as a pay on death or payable on death designation. And third, if neither of those exists, whether probate is required. Let's walk through each of those. First, joint ownership. Now, if you have a joint owner on your account, that person is already a legal owner of the account. So when you pass away, they typically continue to have access to the account. The bank sees them as the surviving owner. So in that situation, access is usually immediate. Next, let's talk about the beneficiary designations, or POD. If your account has a pay on death beneficiary, the bank can release the funds directly to that person once they provide the required documentation. And that usually looks like a death certificate, their proper identification, and completing the necessary paperwork provided by the bank. This process is typically much faster than going through the court system. Now, let's talk about what happens if neither of those exists. So no joint ownership, no beneficiary. This is where things slow all the way down because now the account becomes part of the estate, and that usually means probate. Probate is the legal process where the court determines who has authority to act on behalf of the estate. And until someone is officially appointed, typically this person is called a personal representative. Until that point, the bank does not have authority to release those funds. So what happens in the meantime? The account is essentially stuck. Now, let's pause here because this is where real life issues come up. Families often need access to that money quickly. They may need to pay for funeral expenses that they didn't plan for. They may need to continue to cover bills or handle immediate financial obligations. And they are very surprised often to find out they cannot access the funds right away. Not because they're doing anything illegal or wrong, but just because the legal process hasn't caught up yet. So let me give you a simple example. Let's say that a parent passes away. They have a bank account with about $75,000 in it, but there is no joint owner, just the one person named on the account. There is no beneficiary named as the person who would receive the funds after. So the family goes to the bank and they walk in and say, hey, my so-and-so passed away. They bring the death certificate. And the bank says, we need court documents. Now the family has to go through probate, which can take time. And during that time, the money is not readily accessible. Now, another question I hear a lot is, well, what if I just give my child access to the account while I'm alive? Or what if I just share my login? And again, I understand the thought process behind this, but access alone is not the same as legal authority. Sharing login information does not give legal rights, does not protect your child, and it may even violate the bank's policies. So while it may seem like a good workaround, it is not a reliable or recommended solution. So now the question becomes, how do you avoid this situation? How do you make sure that your family can access your funds when they actually need them. First, make sure your accounts are properly structured. If appropriate, consider adding a beneficiary designation. Review also whether joint ownership makes sense for you and your family, or incorporate those accounts into a broader estate plan. Second, make sure your legal documents are in place. That should include things like a will and, in some cases, a trust, so that if probate is required, the process will be much smoother. And third, make sure that your plan is coordinated, because one of the biggest issues I see is not that people didn't plan at all, it's that different parts of their plan don't match up. Their accounts may say one thing and their documents say another. So you may have someone who lists a pay on death beneficiary as their daughter at the bank, but their will says that it should be divided equally among all children, let's just say. And that's where confusion happens. The key takeaway here is this: just because someone is in your family does not automatically give them access to your bank account after you pass away. Access depends on how that account is set up. And if it's not set up properly, your family may be dealing with delays at a time when they least expect it. So if your goal is to make things easier for your family, this is something worth reviewing now, not later, because a little planning here can make a big difference in how smoothly things go in the future. I'm Attorney Otto. Plan wisely, live confidently, and I'll see you next time.